There's quite a lot of law. I try to avoid talking about too much technical law. In essence, there is nothing restricting a board from issuing shares. If it's a Companies Act company and they've got a single class of shares, the board are at liberty to issue shares. And it might be that you want to control that. If, for example, you've invested money in a company and you've got, let's say, 20 or 30%, how are you going to control what the board does? How are you going to stop them issuing shares to people you don't want them to issue to? How do you control, in essence, control your investment? You don't have a shareholders agreement that says how shares are issued, when shares are issued, and who can also become a shareholder. There's a lot of confusion about preemption rights. People talk about preemption rights. The preemption rights that are talked about in the Companies Act are to do with when new shares are issued. So under the Companies Act, if you're an existing shareholder, and the statutory rights of preemption apply, if new shares are issued, they're to be offered to you first of all. But that doesn't deal with transferring. There is nothing to stop a shareholder transferring his shares to another person. So if you don't think about it and organise it, if you've got a business partner who's got shares, there is nothing in law stopping them transferring their shares to somebody else, unless you have covered it by talking about the other type of preemption, which is offering shares to the existing shareholders if you want to transfer them. So the scenario is you've got A and B. B wants to transfer the shares. Before he does so, he's got to offer them first to A. So that's a different type of preemption. That's preemption to do with transferring shares rather than issuing shares. Again, people don't think about it and don't provide for it. Drag and tag is an interesting piece of jargon. Just another example of how you can control what happens to shares. If somebody wants to buy your company, you might have an argument about whether it's a good idea. It's a commercial decision at the end of the day, whether you buy or sell the company, whether you buy and sell the shares. And you can obviously disagree or not agree, but you're maybe in a situation where there's effectively deadlock, corporate paralysis. You might have one shareholder says, "This is a fantastic offer. Now is the time to sell. We must sell." The other one says, "I don't agree. I want to carry on." So you've got no way of resolving it. But it is possible in a shareholders agreement to provide a mechanism that is fair to everybody. You can have voting thresholds, so you might say that if 51% or 75% agree to the transaction, then you can sell. So there's a mechanism to prevent the logjam. With drag and tag, the person who wants to sell can drag the shares of the minority person. So they're dragged, but they can also tag along. So the other side of the coin is you can't abandon them. If they say, if the seller A in my example says, "Well, actually I've got someone who's going to take my 75% and who's going to leave you on the side," well, the tag is he can come along and get the same deal. Again, people come and say, "We're in deadlock, we can't agree what to do." They can provide for that eventuality by a shareholders agreement.